Hi, I'm Alan Lyles, your moderator for our webinar. Good afternoon, and thank you for joining us for the Supreme Court reverses the Chevron deference, replacing scientists who deal in facts with judges who deal in opinions. As a focus point, the Administrative Procedures Act in 1946 codified a process by which the U.S. federal agencies make regulations. In 1984, the Supreme Court held that agency expertise should receive deference in interpreting ambiguous statutes. The case was Chevron USA v. Natural Resources Defense Council. However, in 2024, the Supreme Court reversed 40 years of legal precedent to give federal judges the authority to interpret the meaning of ambiguous statutes. The case was Loper Bright Enterprises versus Raimondo. What happens now? The implications are vast, touching on every area of public affairs, public administration, environmental, health, education, energy, commerce, and more. The consequences are too soon to see what courses will decide and establish as a set of precedents. We have our panelists today who represent a particularly compelling set of expertise at this point in time. We have a legal understanding with Mr. John Willis, a public affairs academic, pracademic, Dr. William Resch, Bill Resch, and a senior career public sector executive, Ms. Stacy Rogers. A few organizational details before we start. Our webinar is being recorded. Afterwards, a link to the recording will be sent to all who have registered, whether you were here or not. Please enter your questions in the Q&A feature at the bottom of the screen. You will have one or two live questions following comments from each of our speakers with an open question and answer period following Ms. Stacy Rogers' comments. If your question is not answered live, we will do so after the event and share that with our attendees. Our discussants today, keynote for our event, Dr. Bill Resch is an UBALT MPA from the class 2007. His title is Assessing the Political and Administrative Implications of Loper Bright. Dr. Resch is the C.C. Crawford Professor of Management and Performance, Associate Professor of Public Policy and Management, and Director of the CLEAR Initiative, that is Civic Leadership, Education, and Research, in the Sol Price School of Public Policy at the University of California. Bill Resch earned his doctoral degree at American University. His research focuses on public management and executive politics. A common theme in his work is how administrative structure and political environments affect the behaviors, perceptions, and working relationships of civil servants. He has received numerous awards, including those from the American Political Science Association, the American Society for Public Administration, and the Academy of Management. His most recent book, Rethinking the Administrative Presidency, was awarded the Best Book in Public Administration Research Award by ASPA in 2017. Mr. Willis is an author, historian, and widely recognized expert on the Maryland electorate and the state's demographics. He was nominated to be Secretary of State of Maryland and was confirmed unanimously by the State Senate in 1995 and confirmed for a second term in 1999. Mr. Willis is currently an executive in residence in the School of Public and International Affairs at the University of Baltimore. Ms. Stacy L. Rogers, University of Baltimore, MPA 99. The title of her talk is Loper Bright Enterprises versus Raimondo Decision. Operational implications to consider, a practitioner's perspective. In a full and distinguished career, Ms. Rogers retired as the County Administrative Officer, Baltimore County, Maryland. She is currently executive in residence in the College of Public Affairs and the Schaefer Center for Public Policy at the University of Baltimore. Ms. Rogers is also president of the National Forum for Black Public Administrators National Board of Directors. I am delighted that we have such a stellar panel for such a timely topic, and it is now my honor to introduce Dr. Roger Hartley, Dean, the College of Public Affairs at the University of Baltimore, to welcome you. Roger.
Thank you so much, Alan. I really appreciate it. First of all, let me say on behalf of the entire College of Public Affairs of the University of Baltimore, I'm pleased to welcome our panelists today and also all attendees to this special annual event, which is hosted by our College of Public Affairs. The college is a multidisciplinary college dedicated completely to public service, offering degrees and technical expertise in fields as wide as public administration and policy, criminal justice, global affairs, health and human services, conflict management, and even cyber forensics. We do a lot. Just about every brand of public service is really housed and done under this wonderful roof. So I've been pleased to be dean for almost 10 years and worked with this incredible team. The Rosenberg Dialogues, curated by Dr. Alan Lyles, is an amazing example of our educational mission, focusing on important issues of the day. I really want to thank Dr. Alan Lyles. Thank you, Alan, who is a distinguished faculty member in the college and also a fellow of the National Academy of Public Administration. I want to thank him for his extraordinary work and bringing us together for so many years in these types of dialogues. I also want to thank, of course, our funder, the Rosenberg family, and their foundation for the support of this series and support of Dr. Lyle's incredible work. Some more thanks. I'm a big thanker. My thanks also go today to our amazing panelists, each who have a diehard love of this institution, this University of Baltimore. Bill Resch of University of Southern California, Ms. Stacy Rogers, each who are among our most distinguished MPA alums. And well, everyone in Maryland knows Professor John Willis, who's a lifelong public servant in our state, a great teacher, but also our former Secretary of State of Maryland as well. I'm really excited to hear our speakers today on a topic of such great importance. And it's one that doesn't often enter the minds of average everyday people, but the impact of the Loper case and the Chevron case before it and the Administrative Procedure Act that you're going to hear a lot about today impacts the lives of every citizen and non-citizen in this United States every day. The Loper case that many say ended the deference of the courts to the expertise of federal agencies under the famous Chevron decision is really extremely important. Chevron was a decision that you're going to hear more about today, but a decision that demanded that courts provide deference to the expertise of administrative agencies, something that's really not so controversial if you really think about it. These are our nation's doctors, scientists, and other experts on policy and individual issues, and that work in these fields day to day and understand the issues better than anyone, really. The Chevron decision noted that when interpreting agency rules and regulations made with the help of these experts, that these rules and regulations needed to have some special deference paid to them because of that expertise. Rules and regulations are created every day, and sometimes we hear about them as if they're negative things. Rules and regulations are created every day to add flesh to the bones of what are vague policy statements made by Congress that must be implemented on a day-to-day basis. Our leaders in Congress did that on purpose, of course, because they knew that they could not have an understanding of every issue that might be presented under Health and Human Services, for instance, or every issue that would come up on a day-to-day basis. They wouldn't have the time to involve themselves in those matters, right? Because they're making laws, not carrying them out. Ironically, the Chevron decision in 1984 allowed an effort to reduce regulatory efforts made during the Reagan presidency. I'm deeply interested in the impact of this decision, and I'm looking forward to hearing more again today and learning more, as many have been concerned that without it, the courts are not bound by agency expertise solely anymore. Here's a question. Has there been a rush to the courthouse steps by corporate lawyers wishing to block or overturn agency decisions? Or a race to the courts perhaps by public interest law firms on the left, wishing to block the diminishment of agency protections by a new president? I'm reminded too, in the times that I studied for my PhD once upon a time, of the work of Mark Galanter, an important legal theorist who was at New York University. he wrote an important legal piece called Why the Haves Come Out Ahead. And it's one of the most landmark important pieces in law and society. In litigation, he noted for several reasons that those with resources, those who can hire the best attorneys, and those with the time to spend years on an issue tend to win out in court over the rest of us. I am thrilled and delighted to hear the thoughts of our experts today on this important topic, and I'm so proud to have our college's faculty and alums continue on this journey through the Rosenberg Dialogues to lead us to think more deeply about some of the most important issues of the day. And so, Alan, thank you. Stacy, thank you. Bill, thank you in advance. Professor Willis, John, thank you so much. And then I often like to think that people behind the scenes that make things happen, who often don't like me too, Cynthia Opakunle in the college and our friends in OTS for setting up this webinar today. Thank you all, and I'm really excited to listen and learn more.
Thank you, Roger. And now we will hear from, let's see. I see a raised hand, but if we could hold that for just a moment. Okay, I'm not seeing anything else now. So if we can begin with our keynote, Bill, your title is Assessing the Political and Administrative Implications of Loper-Bright. I'm interested in Venn diagrams, so it seems like those are two circles. Do they intersect? Dr. Resch?
Thank you, Alan. Thank you, Roger, and fellow panelists and everybody for showing up. Really honored to be asked to give the keynote lecture here. I have a very fond place in my heart for University of Baltimore. It started my academic career and led me to areas of inquiry that I had not even considered before I stepped through those doors at UB, and that I've developed now as a career since way back in 2007, were the days that it was when I graduated from University of Baltimore. So not to date myself too much. And so with that, I'd like to say, along with my thanks, I also want to preface this by saying that I am not a legal scholar. I am not here to talk about too deeply about the legal implications. But I am trained in political science and a public administration scholar, and with that, that is the reason that the title of my talk is Loper-Bright and its political and administrative implications, because we cannot think about institutions without thinking about the legal frameworks in which these institutions are parameterized. And so I just wanted to give that a brief preface to make sure that any lawyers in the audience understand that, I come at this from a political science perspective. Okay. So, but I do believe that this decision in Loper-Bright Enterprises versus Raimondo will reverberate through our legal and political systems for years to come. The court's conservative majority struck down the Chevron doctrine that both Alan and Roger so succinctly but fully kind of explained. It was a 40-year-old cornerstone of administrative law. And in doing so, they dramatically shifted the balance of power between courts and federal agencies. Chief Justice Roberts, writing for the majority, flatly declared that Chevron is overruled, quote, end quote. From now on, he wrote, quote, courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority, end quote. So this marks the end of an era in which courts generally deferred to agencies' expertise when laws were ambiguous. Justice Kagan, in a very passionate dissent, actually made from the bench, which was unique in and of itself, warned that the decision would cause a massive shock to the legal system. A jolt felt not just in Washington, I'm no longer quoting her, but but also potentially in the workplace, in our communities, and the economy at large. So why was Chevron deference so significant? And what does this demise mean? To answer that, I think we have to explore not only the legal mechanics of the doctrine, but also the political movement that targeted this doctrine for extinction. And let's consider also how Loper-Bright fits into the long-running conservative crusade to dismantle the quote-unquote administrative state. The appeal this victory holds for those who champion smaller government and judicial supremacy and the complex and perhaps unintended fallout that might follow. My comments will focus more on those potential unintended consequences as I see them. And this includes challenges for the judiciary itself, dilemmas for the current Trump administration, and also for future presidencies, and broader economic and social implications. So I'll outline some of these facets, spend just a bit of time on legal doctrine, not too much, turning to some intellectual history and then to real world consequences. If I begin with the Chevron doctrine, right? The Chevron doctrine was established in 1984 through a case, Chevron USA versus the National Resources Defense Council. And it established a fairly simple two-step framework for reviewing agency interpretations of ambiguous statutes under the Administrative Procedure Act. Now, what do we mean by ambiguous statutes? Well, Congress, as a body, is filled with generalists who are expected to represent you on a whole panoply of various issues, represent you as in a general jurisdiction, right? And jurisdictions have many concerns. The people who populate a jurisdiction have many concerns. And we put people into place into Congress to develop expertise, of course, in issues that are important, particularly to the jurisdictions in which we're embedded, but that doesn't mean that they become technical experts, right? And so they can articulate the intent of the public, but with that intent, there will be inherent ambiguities in terms of the technical details that are necessary to implement a given policy. So with the Chevron case, first, a court generally asks whether Congress's intent on the particular question is clear. That's the first step of the two-step doctrine that Congress or that Chevron put in place. And if yes, that intent governs. But if not, the agency's interpretation has to be reasonable. That is, that the court will defer as long as the rule reflected recognition that Congress often legislates in broad strokes and that agencies possess specialized expertise and political accountability that Congress and the courts lack. So in practice, Chevron provided regulated parties these stable expectations that as long as it was within reason, that it fell within the aegis of the agency, that the agencies had freedom to fill in statutory gaps without constant fear of being overturned. But in Loper-Bright, the challenge concerned a national marine fisheries service. It was a rule that required fishing companies to pay for at-sea monitors. But they also pressed for a broader goal, backed by a conservative coalition. While the National Marine Fisheries Service, or I'm sorry, I should say Loper-Bright, was seeking, some type of correction for what they saw as an overreach in terms of making them pay for these at-sea monitors. Some conservative groups jumped onto this as an impetus to overturn this long-standing two-step doctrine. And Chief Justice Roberts agreed. He held that Chevron was at odds with the Administrative Procedure Act, which commands courts to decide all relevant questions of law. And to Roberts, Chevron illegally asked judges to concede their core duty, that is, interpreting statutes in favor of agency views. He concluded that Chevron, again, was overruled and that henceforth courts would resolve this. And legally, this change does three things. One, it eliminates the safety valve that allowed agencies to choose that reasonable path that I talked about when Congress was silent or ambiguous. And two, it invited more litigation. So under Chevron, industry challengers faced, kind of an uphill battle because the doctrine dictated that they, for the most part, would defer to agency opinion. As long as it could stand as reasonable. Now the challengers needed only to convince the courts, or need only to convince the courts, it hasn't been tested explicitly yet, that their reading of the law is superior to that of the agencies. And we can expect, I believe, a surge of suits that are attacking regulations, from environmental rules to workplace health standards, go down the line. And then three, I believe that this creates splits across the courts. So previously, Chevron often produced uniform outcomes nationwide, as all the courts deferred to the same agency interpretation. But with that deference gone, now district and appellate courts are going to be free to pick and choose. And that will lead to conflicting interpretations of the same statute that the Supreme Court may have to resolve. And that's going to increase its docket on perhaps very detailed technical questions. So critically, the majority's rationale rests on separation of powers and originalist or textualist premises, that judges are the only ones that are in place to interpret the law and they should not defer. But it really downplays practical realities. Judges are generalists, just as members of Congress are. They lack scientific, economic, or medical expertise that agencies build over decades. And Justice Kagan, in her dissent, warned that this will swap bureaucratic expertise for the inexpert policy preferences of unelected judges, end quote, which I believe risks inconsistency and error in terms of the application of this new doctrine. Now, a few clarifications before I continue. Not all deference is gone, right? If a statute explicitly grants an agency discretion, such as like the secretary shall set standards as necessary, then, the courts have to respect that clear delegation. And Loper-Bright targets only the implied delegations that arise from ambiguity. Also, this does not apply to past precedents, right? The majority did not automatically overrule every case citing Chevron. And in fact, Roberts stated, at least indirectly, that this will not be applied retroactively. But at the end of the day, Loper-Bright does end that two-step process that I talked about and places the interpretive burden entirely on the judiciary. And I believe that has profound impacts on administrative law, but more so, I'd like to talk about the impacts that it has on our political system and economic system and institutions. I want to just briefly talk about that conservative, kind of impetus towards overturning Chevron. And also give it, due credence, right? That there are legitimate reasons that, conservatives, particularly movement conservatives, and I can define that for you if you'd like me to, but movement conservatives have been against, the Chevron doctrine for some time. This has been many decades that conservatives have campaigned to weaken what we know as the quote-unquote administrative state. That is simply the network of federal agencies, independent agencies, executive branch agencies exercising regulatory power. And there were two, I think, really core normative concerns that drove that project, but there are more. But I'll just focus on two that I know best, which is one, they really argued that unelected bureaucrats, as they saw them, wield power without direct voter sanction. And Chevron compounded this by giving agencies broad latitude over vague statutes, insulating them from judicial scrutiny. And by ending deference, the judiciary reclaims the final say and forces agencies to hew much more closely to statutory texts or seek explicit congressional authorization. And their argument is, okay, yeah, the judiciary is unelected, but by the judiciary being the final arbiter, it really puts pressure on the elected officials to more explicitly delegate, right? So in theory, it pressures Congress. It pressures the more directly elected individuals to legislate clearly if they want agencies to act. Also, the second point would be that from Reagan through the current Trump era, conservatives have really decried regulations they see as stifling economic freedom. They point to environmental and public health actions like the Clean Air Act to regulate greenhouse gases, or CDC's eviction moratorium during COVID as examples of agencies stretching statutes. And Chevron often protected those interpretations as reasonable. And that really got under the skin, particularly of large industry actors. And without deference, agencies might think twice before, advancing such aggressive rules, knowing that courts will be subject to every nuanced independent judicial review. So that litigation strategy was largely orchestrated by the Federalist Society and conservative law firms and think tanks, and they nurtured judges' skepticism of deference. And they cultivated what's called the major questions doctrine, used in a recent case of West Virginia versus EPA in 2022 and Biden versus Nebraska in 2023 to invalidate agency actions deemed to economically or politically significant without explicit congressional mandate. Now, historically, Chevron itself was once embraced by conservatives. In 1984, the decision arose during the Reagan era in terms of an EPA case that was expanding pollution limits. But as agencies later used Chevron to enact more liberal-oriented regulations, it soon became the ire of conservatives. And we're probably familiar with Steve Bannon's 2017 vow to pursue deconstruction of the administrative state. And that's really galvanized the movement in recent years and framed agencies as deep state actors, right? In sum, Loper and Bright is more than a technical ruling. It's a decisive victory in a long-running conservative campaign to reshape political institutions towards this goal, right? To realign power away from agencies and towards courts. Now, this is where I want to focus for the remainder of my talk, which is the unintended consequences that I believe this brings. When you strip agencies of Chevron's safety net, I believe that it sets in motion three major complications. And the first I alluded to is judicial overload and uncertainty. With increased litigation, somebody has to arbitrate that litigation, right? Agencies are going to face many more challenges. Courts are going to wrestle with technical questions once left to specialists. Lower courts might diverge. That's going to spawn splits, as I talked about, that only the Supreme Court can resolve. That's further going to strain its docket. And it's going to impose questions to, again, generalists that might determine how many parts per million of a given chemical should be in your waterways. Now, do you want, Clarence Thomas or Justice Kagan, for that matter, deciding that? Or would you prefer someone who has a degree in chemistry or, the applicable sciences? It's also probably going to lead to a lot of inconsistent rulings. If you don't have this standard of deference, one district might uphold a rule while another strikes it down. And businesses, states, and agencies are going to face patchwork regulations as a function of this indecision or inconsistency, I should say. And one state's power plant might comply. Another state's might be pending litigation. Another state might have had a ruling in their favor. And all this unpredictability is going to undermine confidence in both government and markets and will lead to a race to the bottom in terms of regulatory integrity and consistency. Also, a second major point in terms of, unintended consequences is going to be the loss of expertise and policy quality that we have currently. Again, these judges lack the scientific, economic, or technical backgrounds of agency staff. We have fields like environmental science, public health, financial modeling. Judges have to rely on, or will rely on, briefs, on amici or amicus briefs, which can vary in quality and bias, right? And the risk of poorly informed decisions is going to grow. And with that comes short-sighted interpretations. Agencies often develop very detailed bodies of precedent and data over decades. Judges, by contrast, view statutes in isolation. Their rulings might ignore practical realities, operational realities for the agency, or overlapping legal realities and unintended costs. What some have called the inexpert policy preferences of unelected judges. The third, which I think might resonate the most with the current climate in terms of unintended consequences, is weakened executive capacity. The first Trump term saw a brain drain. Hundreds of scientists left the EPA, Fish and Wildlife Service, and other agencies. The second Trump administration has doubled down on what's known, or what some scholars call, structural deregulation. That is, efforts to force attrition in terms of expertise from agencies, repeating and even deepening that cycle of attrition that happened, over 4 years ago in the first Trump administration. And with fewer experts, agencies then are going to struggle to craft legally defensible rules. And one must remember that even if your agenda is deregulatory in nature, that you have to go through the Administrative Procedure Act in terms of process of basically taking a rule off the books is the same process in terms of putting the rule on the books, right? But if it is deemed to be an arbitrary, exercise, if it is deemed to not be substantiated by the explicit delegation of Congress, that action is just as vulnerable to being overturned by the courts as a regulatory effort, a positive regulatory effort, in terms of trying to strengthen regulation as opposed to deregulating. And so then you can see that, while, the conservatives that are deregulatory in nature might applaud the rollback of rules, they still need those agencies to implement policy, right? Whether deregulation or essential services like disaster response or food safety. So while the Trump administration tries to rescind, various laws or regulations, or maybe add a citizenship question to the census, those were struck down not due to Chevron, but because of rushed, perfunctory justifications. And the same is true with the current push towards tariffs. It's a symptom of sidelined expertise. And so future emergencies, whether it be pandemics, cyber attacks, really risk being hampered by judicial second-guessing of agency measures. But on top of that, the structural deregulation that's already happening as a function of the Trump administration is going to make the courts view even more skeptically agency action, whether it's deregulatory or regulatory in its nature. So finally, or close to finally, I'd just like to pick out some of the potential winners and losers of the current doctrine, but we'll see how this shakes out, right? But these complications that I just talked about interact in a very vicious cycle. More litigation and inconsistency erode agency morale. Diminished capacity leads to weaker rulemaking. Weaker rules invite more litigation. The ultimate victims are the institutions that are designed to protect public health, designed to protect our safety, designed to protect or to establish consistent and fair markets. So the winners here I see as large corporations and industry groups. They're going to gain the ease of challenging regulations and pressure agencies to issue more narrow rules or none at all. And that, amongst large corporations, that includes well-funded litigants, but also the conservative legal network that pushed for this doctrine, like the Federalist Society and their allied think tanks and law firms. They now have a much more favorable judiciary for attacking the administrative state. And then also finally, the deregulation-minded politicians, they're going to achieve conservative policy goals through the courts without having to pass litigation. So actually on the converse of the idea that this is going to pressure Congress, actually Congress, those that are deregulatory in their orientation, don't have to do anything. They could sit back and allow litigation to build up. The losers, I believe, are going to be first workers and labor unions. OSHA and labor protections are going to face a much tougher legal scrutiny. It's going to risk, I believe, more workplace injuries, wage theft, weakened collective bargaining. Consumers and general public welfare, I believe, is at risk in terms of agencies like the FDA, Consumer Protection Safety Commission, Consumer Financial Protection Board, lose leverage to protect against defective products, financial predation, and unsafe drugs. Marginalized communities that were already previously marginalized shall be marginalized more. Environmental justice protections, consumer safeguards, all of that is at risk and shifts power, to the courts, where resources and legal firepower matter more than expertise or public interest considerations. So in conclusion, I should probably make some predictions, although the predictions are never something that you really want to do as an academic. But I'll give it a shot. Okay, so what do we think is going to come next? One, I think that we have to watch how district and appellate courts handle challenges. Are they going to apply de novo review narrowly, respecting implied expertise, or broadly by substituting judicial judgment? How are the agencies going to adapt? I think that the agencies are going to build thicker rulemaking records to invite more amici briefs and seek explicit congressional clarity. But Congress, of course, remains gridlocked, and so clear, delegations are going to be unlikely, in my opinion, unless you have supermajorities, which is also unlikely. Politically, I think you're going to have dissatisfied constituencies of workers, consumers, environmental advocates, and they're going to push for legislative fixes. They're going to push at the state level for protections and even renewed deference to, a new kind of deference statute to be put into place as opposed to relying on court doctrine. Now, whether, again, Congress can muster that, it's going to be uncertain. Then, importantly, I think that judicial legitimacy is going to decrease substantially, and it's already decreased substantially, but decrease even more. The Supreme Court really faces a paradox. If it asserts power, it might undermine its institutional credibility if it's perceived as partisan. And indications from opinion polls are that it already is, right? Future adherence to major questions and non-delegation doctrines are going to very much test whether the court applies these principles evenly or selectively. And in the longer run, history suggests that extremes provoke countermoves. The New Deal court packing crisis taught us that judicial overreach can provoke backlash and recalibration. And if Loper Bright's fallout, of what I'm predicting of chaotic regulation, governance failures, et cetera, becomes too pronounced, we might see a renewed demand for administrative state capacity that could take the form of new statutes, reestablishing deference, et cetera, et cetera. Now, for us, for scholars, practitioners, this is an urgent kind of research agenda, right? We should track litigation outcomes, analyze agency rulemaking strategies, assess the real world impacts as they take place on health, environment, and markets, and explore what democratic accountability mechanisms exist when both courts and agencies falter. Ultimately, I think this invites us to rethink how a modern democratic state governs in an era of complexity. And we have to find a sustainable equilibrium. And right now, we are certainly not at an equilibrium. It's very shaky out there, right? But that equilibrium, that newfound equilibrium, I urge us to think about how that will uphold the rule of law and democratic accountability without paralyzing our institutions or sacrificing expertise. And Loper Bright might be the high watermark for judicial authority, but its legacy is going to depend on how courts and the agencies and elected branches navigate the trade-offs that it's unleashed. And so with that, I thank you and look forward to the other panelists' comments.
Thank you, Bill. Thank you very much. That was both expansive as well as specific in framing the issues that we had before us. Some aspects of it remind me of Tip O'Neill's comment that all politics is local. And when it doesn't matter how red the district, a Superfund site is going to be in your neighborhood, that can affect the between period, the every 2-year elections, and draw attention to being responsive rather than being a good soldier and following party discipline. What I would remind our participants is if you use the Q&A, put those in there, and I will ask those if they seem to fit with each of our speakers. If not, after Ms. Rogers finishes her comments, then we'll go through those. Having said that, I'd like to next introduce our speaker, Professor Executive in Residence, John Willis. And I'll remind you that Mr. Willis is a JD Harvard Law. He was Army Judge Advocate General Corps. He has a distinguished service career in state government. And while Bill framed this larger issue and the multiple dimensions of it, now if we can step into the level of the state and the way in which someone who functioned as a Secretary of State for a state would perceive the changes under this Loper Bright. John?
That's a big question, Alan, and I wanted to follow up a little bit with Bill. Bill, I think the winners are the lawyers and the media.
You're not wrong.
When I was asked many times after the 24 election to kind of comment on the election, and my phrase that I use, I'm doing another presentation this Saturday, is chaos, conflict, and I think ultimately corruption. And I think that's what's going to follow out of the Loper decision. It's going to be, and you started articulating the potential for chaos and conflict. I mean, there are 677 federal district court judges spread among the 13 circuits, appellate circuits. They don't all agree. They don't all see the world in the same way, and they have different educational backgrounds, different political connections, different orientations, and it's very easy to see conflicting decisions emerging from the districts and the circuits. And the Supreme Court is going to be much busier than it anticipated whenever it poses a change in well-settled law. I'm not sure. I was surprised in doing research. And Alan, I feel like I've taken a whole course the last 60 days. I was and I've learned this in government, in decades of government, you really should try not to overreact. And I think a lot of the legal scholars, oh, the other winner is academics like Bill Resch, because there's going to be plenty of articles to write and plenty of things to study. And so academics and lawyers win. And then the third winner is the media, because they love conflict and chaos, and that helps them. But in terms of our students here and as us as citizens trying to figure out how to navigate this, I agree with part of Dr. Rush's short-term analysis, but I think the long-term, this decision is going to get revisited, and it may get revisited more quickly than people think. And in fact, just recently, the Supreme Court in a 7-2 decision affirmed the FDA's rules on nicotine additives in smoking devices and natives. So you're going to get all kinds of things that appear to conservatives as being federal overreach, but they're going to get supported by the courts. So where are they? And it may be an issue by issue situation with regard to what the consequences are. So your typology there of increased litigation, what's the effect on agencies, and the unintended consequences is, I think, a good frame for people to continue to follow this issue. As I said, I took administrative law from some of the same professors that the justices on the Supreme Court had when they were in law school. And we certainly got different visions of what administrative law was supposed to be. And I don't think, in a lot of the discussion, I was surprised that there wasn't, Dean Hartley, an overwhelming rush to the courthouse. I did not find that. I found a lot of concern in the literature, in the ABA journals and the legal journals and the law firm publications, and what corporate lawyers were advising their clients. They were more concerned about how do they prepare for the next case rather than rushing right in to file a case. And even recently, in looking at recently decided cases, I don't see the overwhelming response that Justice Kagan kind of was fearful of. And maybe that was because Roberts said, we're not overruling, so don't come back here with the 18,000 cases that Chevron were cited as relying on Chevron. Don't run back right away because we're not going to deal with it. Maybe that's part of it, but I expect it to be revisited. And the other thing, and one of the reasons I'm here, and one of the reasons, I like the University of Baltimore, is I focus on state and local government. And so all of this discussion at the state level, do you realize only 14 states have a Chevron type rule when their state Supreme Court is reviewing state statutes and regulations, so that the 2/3 of the states are already under a different standard, a more the traditional APA standard. And so you get language of arbitrary and capricious. And of course, you raised, Dr. Resch, the delegation of authority questions that are always there with an agency. What did the legislative body do? What is the action of the agency within the scope of that delegation? Was there any direct decision to be made? Were they given any kind of hearing function or authority to, determine facts? So those questions have been regulated. And in Maryland, we don't have a Chevron type standard. We've never had one. So we're doing all right, under the old standards. And so I don't expect any change and we have, I think, a pretty good, now we're Supreme Court, we used to be Court of Appeals, but our Supreme Court, I don't think, is going to take Chevron and change anything here in the state of Maryland. And so you understand that while the media focuses on what happens in Congress, 50 state legislatures are also active. And 90% of the cases in America are in the state courts. They're not in the federal courts. So nobody should leave and run out and think the world is falling or that their local health department has no authority to conduct an inspection, because they do so under state law. One of the other consequences you might want to add to your thinking is, how is this going to impact states? And there may be some states that want to follow the federal government, but there are other states like Maryland that are not going to follow the federal government, and in fact may impose. I was thinking when it came, for example, to the recent controversy, the FDA now doesn't have enough inspectors to go out and inspect milk, right? This happened during COVID. What are we going to do with meat packing plants, and who's going to inspect them? I can see some states rushing in under their own independent authority to add layers of protection for environmental standards, public health standards, and say to the federal government, stay away, we'll send our own inspectors in, and we'll decide what can be sold within our state, based on health standards, not based on commercial commerce clause questions, but based on public health standards. So that'll add to the conflict and the confusion between the levels of government. And so, I'm a little more optimistic long range from Dr. Resch, in that I think there will be political repercussions coming fairly well. 26 is already here. I mean, people are announcing candidates and campaign committees are forming. Money is being raised constantly on both sides of the spectrum. And then, 28. And then I think external events are going to cause people to rethink. And it could be, I hope it's not another pandemic, but people keep forgetting this about COVID. We lost 1 million people in this country. 1 out of every 331 people died. If that happens again, one thing is the agency at the federal level, the loss of expertise is going to be significant and is going to cause public reaction that's going to prompt some rethinking about the role of agencies. And I think the food industry is at risk now. I saw a headline today which was even scaring the White House people, when Target and Walmart and stores that people use every day suddenly have empty shelves, whether it's because of goods not coming from overseas or the inability to produce. That's going to push for change. Now, unfortunately, the big picture, in addition, my always looking at the state and local impact, is I view the Chevron decision as part of a bigger realignment of the relationship between the three branches of government. What is the role and function of the judiciary? What's the role and function of the executive, and the role and function of the legislature? And we know the Roberts Court, although I looked this up, it was quite interesting. I printed out, I give it to you, Alan, all of the reversals of precedent in the Supreme Court back to the 1800, right? And this period, the Roberts Court, while they've been active, there were other periods of our history that were just as active. Certainly the 1930s, you made reference to that a little bit, but the 1880s. So there had been other periods where courts were active in reversing precedent, and in their constitutional decisions, as well as their precedent administrative agency decisions. So I always have to step back and think, we've been through this a little bit before, and where did we end up? But I am concerned about the current Supreme Court injecting itself where prior Supreme Courts have not gone, all the way from its presidential immunity decision, which I think is just narrow-minded and short-sighted, and they're going to have to deal with that head on when they have a president who doesn't want to follow their orders. So that's coming to a head here in the next couple of months. So we're going to have conflict between the judiciary and the executive branch. And then we're going to have judiciary and Congress. And Congress, unfortunately, is basically dysfunctional in terms of passing anything substantive to try to fill in the gaps. I noticed in rereading the Supreme Court decisions that word I loved in law school was the interstices of the law, the gaps in the law, and how do you fill those gaps in? And Congress, I think right now is pretty incapable, or they'll do what the Republican Congress did on elections, which is a whole separate topic, Alan, but they just overreach there, taking away authority of state authority. So I worry about the judiciary reaching out, even on the orders of deportation. They're taking extraordinary actions, and observers of the Supreme Court have noted that their use of the shadow docket, their use of these temporary orders is far beyond what other courts have done in our history, and query whether that was what the framers intended, for the Supreme Court to be looking over the shoulder of the president for everything that happens. Now, this president's taking advantage of it because he thinks he has the votes to do what he wants to do, and he's find out, hey, maybe he doesn't. And so there is a battle there that's playing out before our eyes on a daily basis between the branches of government. And I view the Chevron decision as in that context. It's part of that legislative, judicial, executive authority. I think the big irony of the Chevron, and Dr. Resch talked about it a little bit, is okay, you won, now you're in charge. What about your rules and regulations? And so if you try to abrogate a rule, whether it's in labor management relations or in public health or environmental, what's to prevent a litigant in the first district in New England, rushing into the federal district court in Boston and getting a favorable opinion against the new Trump administration rule? And they're going to be hard pressed to base their rules on scientists because they're firing all the scientists. I mean, seriously, they've got a real problem in terms of implementing whatever their proposed policy is going to be, because if Chevron is no longer a protection for administrative agencies, it becomes a weakness for their implementation of policy. And that's a big, as you say, unintended consequence. The agencies themselves, my bigger concern, I mean, Chevron is a legal doctrine, and lawyers are going to figure out. I know Justice Kagan said, well, special exception, we made one up, but lawyers are going to be able to parse around the sentences and the language of the Chevron decision to try to achieve their result. Now, whether I know some of the environmental lawyers around the country, they're going to win some cases. They may lose more of them, particularly on fossil fuels, but they're going to win some of them because Congress, the statute is more clear than some of the conservative network people want to believe it is. But the bigger problem in this country between this battle between the legislature and the judiciary and the executive is the Trump administration itself, which is putting an all-out assault on administrative agencies. And they're not just changing the rules. They're firing people, they're cutting budgets, basic functions of the government are being attacked by the government itself. And to me, that's the bigger social political issue for us as citizens and what the fallout. And I just fear some bad things are going to happen in those areas. I mean, the environmental pollution, or even FEMA. FEMA is a shell of what it was 6 months ago. And if we have a natural disaster, whether it's floods in the along the Mississippi River, or it's hurricanes next fall in Florida, the public's going to suffer as a result of this destruction of the administration from within, added on to the complications of the Chevron decision, if agencies can muster the technology and competence to go back in and promulgate new rules. And unfortunately, if the current Congress is, I don't have much faith in, but if you get a new Congress after the 26th election, they may rush back in to provide more clarity on certain areas and certain issues than we have right now. In the meantime, we're going to be muddling and just hope we have better weather and hope we don't have more infectious disease outbreaks and we all have enough income to keep us going through these tough economic times we're going to face. So I don't know whether that's positive or negative, but that's kind of a perspective from the state perspective is, hey, Chevron, you're talking like we've been living with it for a minute, Maryland rules and regulations. I guess one other thing to say for the audience and everything is keep this in mind. Understand that there are thousands of laws and there are hundreds of thousands of pages of rules and regulations coming out of all the agencies. So when we're talking about a single decision about whether or not a boat, if a commercial fishing boat has to pay for an inspector to be on board to monitor catch limits, there's hundreds of thousands of other things going on that are not subject to that decision and that will be litigated on both sides. And that's part of our system too, and that's going to take a while to work its way through the system. And I quite frankly think, I've had the privilege in my career to know some of the justices over the years and to know a little and to meet half the court that's there in various circumstances, either at judicial meetings or law school meetings or whatever. They're going to be a lot busier than they expect it to be. And it's going to tax them. And they're going to be in the public eye even more, which may, well, we really wanted to overturn Chevron and we understand. And I actually reading the cases understand the notion of what is the role of the court under the Administrative Procedure Act and what is the role of the agency. And I understand the theory, but their workload will increase. And I bet you they're going to be, as Justice Kagan said, plenty of exceptions that are going to be in the court's docket over the next year or two. All right, I'll stop there, Alan. Answer questions.
Thank you, John. I think what we're looking for is just that. What is objective and what is real, not so much what's positive and what's negative, because that starts to impute other kinds of values. And we could look at outcomes and effectiveness. Before we have some questions, and we had a hand up. If you have something you want to say, please post it in the Q&A, and we'll address that after Ms. Rogers' presentation. A concern that I have that pulls through from what Bill said and John, what you've said, and I think it may relate to what you will say, Stacy, is I'm concerned because of the nature of the electorate right now, that some of the most basic features are poorly understood. The Annenberg Foundation, in a Pew poll in 2017, asked for adults, what are the three branches of government? Only 26%, about 1 in 4, could name the three, not even say what they are. And when I saw that, there's more current data. It's a little bit better, but it's still a problem. And I'm thinking, how do we communicate with a broad audience the information that we know and that's important for them to know when the foundation has so many gaps? So I leave that there till after Ms. Rogers gives her perspective. Now, we heard from a academic who understands that you need evidence and data, and you need to understand how to put this together to make clear what's occurring and what are the likely consequences and what is yet unknown. And with John, he has framed nicely in terms of the plethora of legal activities that occur without having had Chevron to begin with. So what does that mean for those that won't have it? And you speculated on a number of those issues also, John. So thank you. And now, Stacey, from a practitioner's perspective, now I'm thinking that what you will share with us is from somebody who has to make it work.
Yeah.
What is your perspective?
Well, thank you, Dr. Lyles. Good afternoon, everyone. I have a few slides I'll attempt to share, but just up front, I want to say that to my colleague, Dr. Resch, we both came from that UB environment where we understood the role of an administrator, the role of an MPA. And I agree with you on the winners part of this. It's definitely the lawyers and media. The media drives so much of what the average person understands about the government. And I'll say that's not always accurate. The media, especially the push of media is with generations now who receive just about all of their information or what they know about the government and about what's happening from medias that have starkly different positions. So I wanted to say I concur with that. This is heading to more litigation, no matter how you look at it, even if you look at it from a positive. And I'll say I have had to administer programs or administer laws and write regulations based on federal final rules at every level of government. I've had the honor of working at the federal level, the state level, and the local level. And I'll say some of the challenges in implementation have to do with ambiguity and how we sort those things out. And people who do this work, the boots on the ground, we rely on subject matter experts. They're not decisions that are made in isolation by one body or one person. And that's really challenging with this change. The 13 appellate circuits definitely have varying opinions when you look at decisions made, over the course, even before this action took place. And that devolution back into that arena invariably, which I'll talk about last, will ultimately lead to disparity because of the deciding decision makers at the court level and how administrators will have to implement in their jurisdictions. You see stark contrasts in this happening already from my perspective. So let's see if technology will work with me here. And again, I share from my experience, if you will, as an administrator who has to take the legislation and the final rules and then come down to the level of implementation of regulatory regulations that have to be promulgated and then standard operating procedures. So I thought long and hard about this in terms of was there anything positive when you look at it from a practitioner's standpoint. And what I feel, with this change, what are the implications from a practitioner's perspective? There are two areas that I would say you could view as a positive, but again, it leads back to litigation, because in this setting, these actions or interpretations coming from the court, in a lot of instances, organizations don't want to have to litigate. They don't want to have to go back to seek clarification. But because the ultimate decisions are now being made by the judicial branch of government, then practitioners have to seek clarification, because Mr. Willis, as you indicated, and I agree, there's a blurring of the lines when it comes to three branches of government for me right now. Like, who's on first and who's responsible for what? Because the practitioner who has to make things happen and public administrators, we are looking at the iron triangle, as it was called when we were MPAs early in our career. We look at the judicial branch as the arbiter when there's, decisions that have to be made, but they're not the technical experts. The agency subject matter experts help to weigh in to clarify things. Well, in this change, that's not the case. And then another strategy again, it's legal though, is agencies will have an opportunity to look at this more so from a legal strategy and try to determine still what's in the best interest of the individual community and the best interest in those we are to serve. And that's the thing that concerns me the most, that input from the community is just getting lost in all of this in terms of how we make decisions. And even from an implementation standpoint, blue ribbon commissions that weigh in on things, all of that part of how local governments operate is kind of pushed to the side with decisions that are being made at the judicial level and then having to be implemented by public administrators who basically their hands are tied in some instances without having to go back to seek clarity or even challenge the laws, which really slows down the progress of work that needs to be made, to make, to get things to communities that are needed. That's the biggest challenge I see from a practitioner standpoint. If it comes down to the court that it must be implemented this way, then you got to go back through a legal process to make any kind of modifications. So I tried hard to see if there were indeed avenues where public administrators can take advantage of the current climate, and also, with these decisions being made, especially at the appellate level, because there's definitely disparity there. So back to the negative implications, my colleagues have laid it out for you, but I want to refine and talk about it a little bit further from a practitioner perspective. In the instance of uncertainty, practitioners face greater uncertainty in a regulatory environment about whether they can really make the changes and have the impact that communities need. As I said earlier, judicial interpretations may differ from the organization's mission. It may differ from what the specific community needs are. I mean, I've worked in numerous communities here in the DMV. No one community literally, you address problems from a strategic approach by getting input from that community. But it's going to be harder to do that, particularly if it is far more rigid in how you have to implement. And I think administrators, especially based on the mass exodus, some resulting back from the pandemic, where some of the seasoned administrators had the ability to go And now with the mass exodus at the federal level, based on the current administration pushing the brain trust out of organizations, people are very hesitant, to try to challenge other than doing things by the book. If that's what the courts say has to be done, some people will take that very narrow approach to do it. So that's really taken away a lot of the flexibility and innovation that you find that public administrators have to rely on to meet the challenges and the needs of local community. Policy inconsistency. This goes back to the appellate courts. We can just look at how decisions that come out of the various circuits, they vary across the country. And I dare say that one of the challenges that should concern us all is the rollback and devolution back into total state decision making. We'll look, for example, some of the decisions with the devolution of the Federal Department of Education, placing decision making back into the state side. But then if issues come up of disparity, who's the arbiter? How is that going to be? It rolls back up to the Supreme Court. So it's just a vicious cycle of litigation. But we know that the potential for disparity definitely is there depending on where you are in the country. The other part that I feel is increased litigation risks when it comes to agencies who are seeking to implement the requirements that come down, the decisions that are made, and now without subject matter experts and being made by individual members of the judiciary, that there's no one individual who has the subject matter expertise to make unilateral decisions, whether that's a judge, whoever it may be. In an agency, you typically make decisions and approach problems and development of implementation strategies with an integrated group. You have subject matter experts who sit at the table to help work through a lot of the micro issues that come up that you face in implementing. Two examples with the implementation of the Affordable Care Act. I was working at the federal level, and what we needed to do to ensure that the Affordable Care Act and the actual online access to application could be done in the 50 states in a similar way. It took many, many people to sit at the table to make sure that what we were doing would work and be equitable across the nation. Now we're saying that we're having legal colleagues make certain decisions about how things are going to be implemented when that technical expertise is totally missing. For a practitioner, that's the most frightening thing you want to hear, because your job is to make it happen. And the way this is playing out, again, I believe that practitioners' hands are going to be tied. And what it's going to cause is more litigation that is brought forward from the advocacy community. So it all leads back to this vicious cycle of litigation that's driving everything. But I'll say a little bit more about the advocacy community and how this is, I think, going to have an impact locally on local communities. The last one in this segment is about a shift in agency mission and focus. Depending on the decisions that come out of the judicial branch of government, how they play out and then come to agencies to implement, they may not be aligned with the focus of that organization and what's happening in a specific community that needs to be met, because there's no one size that fits all. That's what the regulatory piece and also the standard operating procedures give the flexibility for organizations to meet the charge that we're given, but to implement it in a way that's going to work for that particular jurisdiction. I'll use the example of the pandemic to demonstrate that. Just here in Maryland, the 24 jurisdictions had a mandate to put in place a testing procedure, a process that would work for their community, for their citizens or residents of the community. We all discussed that the CAOs in Maryland, we relied upon each other to vet to see, well, how are you doing it? How are you using the limited resources we have to implement this to meet the needs of our communities? And we were successful, but our implementation processes and strategies did not look the same. It was done differently based on what was going to work best for an urban jurisdiction, a rural jurisdiction, a suburban jurisdiction, the makeup of the jurisdiction in terms of the composition, seniors, communities of color, when people work, when people were available. If you don't have that level of flexibility to implement major initiatives, our communities are not going to be served adequately. And that's, very, very troubling. So I want to switch and go to the broader implications that I thought about in thinking about this change and pushing everything to, the judicial branch, which isn't the policy arm of the government. It's the arbiter and the interpreter. But to ensure that communities get what they need, it has always been the operating, the departments and people who know the subject matter the best, the scientists, the researchers, all of us who have come to and worked in the public sector because we serve the needs of community. So the thing that I feel is at risk for, how the community feels about government and how we operate, I think the citizens are going to become more skeptical of government agencies if they perceive that basically the judicial interpretations are driving how their needs are being met versus public administrators. Because our charge is to serve those in need or to ensure our communities are safe, to ensure that our water source is safe, that our food is safe. But with all of the dismantling at the federal level and devolving and abolishing, if you will, certain federal functions and giving the judiciary the authority, if you will, to make decisions, unilateral decisions, as opposed to decisions that have been arrived at by the collective subject matter experts, I think we have a problem with growing distrust of the government, challenges to the advocacy community. We know that this leads back to litigation. Many community organizations will not be able to face, and advocate for policy changes and certain protections that we need because they may not have the legal resources to fight these battles if everything ends back up in a legal environment. So smaller advocacy groups, grassroots kinds of advocacy pursuits, I think will be challenged. And then again, the legislative backlash you will have, and I think it was Mr. Willis, you mentioned this, or Dr. Resch, you may have mentioned it, that you have the corporate folks who have money who can swoop in and they have the resources to just litigate and take on certain legislative challenges where the community level grassroots folks don't have that ability. And the litigation is going to drive everything. And again, last, like I said, the potential for increased disparities, the more things devolve, the more we run the risk of inconsistent application of the law across the country. And depending on where you live, depending on, what circuit certain decisions come out of and how that plays out at the local level, I believe we're going to see far more disparate applications of law in communities when we get to the community level, because it's being driven from the judiciary versus back end decision-making, integrated approaches to delivering services, and, the regulatory piece, standard operating procedures that can be consistently applied. And we can have confidence that that's being done by individuals who have the skills and expertise to make those decisions. That's why we do this work, or those who are still doing the work. That's why we do this, to make sure that we're meeting the needs of the communities that we serve. We're using, sound input from community and subject matter experts. That's how I see it from a practitioner standpoint, which is a little bit, it's consistent with my colleagues, but it's a little bit more boots on the ground. How is all of this going to play out when communities have needs that need to be met? But decisions about how those needs were met were made in isolation as opposed to an integrated approach. Thank you, gentlemen.
Thank you, Ms. Rogers. So I want to thank everyone. And for those who are still on the call, what you've heard are not just perspectives, informed perspectives, but what you've also seen is that each of these persons, these are the values that animate their lives. And I think sometimes that gets lost in discussions because we're more than just analytical, and there are values that drive that. And that's what we've just heard, for example, for Ms. Rogers, as well as our other speakers. We have several questions, and I think that we're probably going to finish this earlier than the time indicated, but that would be okay, I'm sure. I'm going to put two of the questions together, and whoever wants to take the lead on any aspect of it. So the first is, public administration scholarship recognizes the hollowing out of the administrative state. perhaps of the very expertise and experts that resided within the agencies. It's now a management state that we've moved toward, with agency personnel managing contracts with private enterprises, rather than fulfilling the actual duties that the agency's meant to do. So, my question is more about the value of reliance on agency expertise when agencies themselves might rely on equally biased private enterprises that help generate the rules and regulations. This is particularly true at the Securities and Exchange Commission and the Consumer Financial Protection Board, with industry insiders entering the revolving doors of regulatory bodies. Now, an obverse of this is the next question, which says, as Bill Resch knows, executive regs have increasingly reflected presidential policy preferences rather than agency expert preferences. The Trump administration manifests this. Do you think a paradoxical effect of Chevron's repeal will be to weaken the president's ability to prevail in the courts with his executive initiatives? So we see a similar question, but from two different directions. So whichever way you would want to take either aspect of those questions, I'll leave it open.
Since my name was invoked, I can try to start to address this. So first of all, thank you for the questions to whoever the anonymous attendee was, but also to Frank Thompson. And Frank, I've learned a lot from Frank over the years. He's written on the subject of the administrative presidency and informed a lot of, what I know. And so, I think he could probably answer this better than I could, but I will, as I think he's setting the table for me to say, maybe to answer in a way that he already knows, but to say that I do indeed. I mean, in some of my comments, I talked about the kind of structural deregulation that is happening. And by the way, that's a term that I borrowed from Freeman and Jacobs, who are some brilliant administrative law scholars, but it fits with the administrative presidency literature from political science and public administration. That says that, presidents actively, and also aligns with the first comment, they actively, take on kind of managerial interventions into agencies to push policy administratively towards their respective preferences, right? But with that, right, those managerial interventions, particularly, or that structural deregulation, if you will, when it's meant to kind of undermine the mission of the agency, right, and undermine the existing expertise of the agency, that, as I argued in my statement or in my original thoughts, that this could have the unintended consequence for the Trump administration when they're proactively trying to deregulate, but in doing so still have to follow Administrative Procedure Act, still have to, make a cogent argument as to why they're deregulating in a particular direction, right? That logic may not hold up in court. It might be seen as arbitrary and capricious on behalf of the administration. And so if you load the administration with industry insiders, as the first commenter said, and the presumed impacts are seen as being one-sided, is seen as being arbitrary, then these regulations or deregulations might not hold up to judicial scrutiny, right? I will say a little bit towards the first comment in terms of industry insiders entering the revolving doors. I'm a little bit more, I would say, I don't want to say apathetic. I'll say I'm less concerned about that if we have strong oversight within our administrative complex. And that is not to say that we do currently, but when we do have strong oversight within our administrative complex, when we do have strong transparency, that I actually welcome industry insiders to come in and out of agencies over time, because I believe it lends expertise that non-industry insiders might not have. However, with the lack of adequate independent oversight, with the lack of transparency, then it is indeed problematic. So it's not to take issue with the first comment. But that being said, we need to think about some of these sectors in which we have, regulation are very complex, and many times it behooves agencies to work with industry in order to understand the complexities themselves and on the ground complexities, right? And so, and also, even if you think of it in terms of just a true, like purely kind of rational ambition, material interest orientation of the regulators themselves, right? Who would an industry insider or who would an industry actor want to hire out of an agency? Would it be the person that was ineffective in regulating them, or would it be the person that's effective in regulating them?
Right.
And so I believe that that having open labor markets that that reward competence in that respect, I think are good things in some respects. But that being said, I also think that is contingent on having good transparency laws, good agency oversight, or strong agency oversight in place, which I don't believe that we have currently.
Thanks, Phil. Stacy has her hand up. She has something to say
Well,
about that.
Dr. Rush said it right at the very end there, that the strong inside agency oversight, because when you bring contractors in to help you do something that you need to get done, you have to have that oversight so you can ensure that you're receiving what you're going to get done, what you're seeking to get done, or what you contracted for. And in a lot of instances, you need that, as an administrator. If we're charged to get something done, we have to get that industry expertise to help us get it done, because it's not often the case that everything you need to accomplish a project or implement something exists within the organization. But the transparency, the monitoring of those individuals who come in to help you, and the accountability, from the agency standpoint, that they're doing what you need them to do on budget and on time. That's important. But with the gutting of agencies, at the federal level, it just, again, is a concern. Who's going to be there to be able to do that, to play that role? Because that's what strong administrators do.
Thank you, Stacy. John, you were next.
Thank you. I think Dr. Rush has outlined the problems, but I wanted to draw attention to something I wanted to reference earlier, and that is the problem is the administration itself. I mean, that's why they fired all the inspector generals. And so your concern about transparency and oversight, they know that, and they don't want it. And that's a real concern for the rest of the institutions and for the public. And
Absolutely.
The other thing that's very curious is, Trump has issued over 130 executive orders in 100 days, right? And one of those was the creation of DOGE, and everybody should go read it. It was on February 19th, 2025. And just a couple of weeks ago, 2 weeks ago today, he issued a memorandum of implementing the law from recent Supreme Court decisions. And Trump's citing Loper, right? That's one of the 10 cases he wants agencies to review, and agencies are to repeal regulations where they were supported by a Chevron decision. And so the executive here is trying to take over the role of the court and say, well, this was a improper decision based on Chevron, and they're in there trying to advance. That's going to end up in litigation, because whoever's disaffected by that action is certainly going to pursue it. So chaos and conflict, and without the oversight, that's the corruption will follow. And I predict there'll be, just like in post-Watergate, we'll have stronger laws 5 or 10 years now that we have now on ethics and rulemaking and revolving door, etc.
Thank you,
Every
gentlemen.
president tends to publish ethics rules at the beginning of their term, and you may see some of those work their way into statutes.
Thank you, John. Roger?
You're muted, buddy.
Thank you very much. I muted and unmuted. Frank Thompson's comment in the discussion here reminded me of something, fairly simple that we learn in economics, but we often forget, which is the concept of market failure and why governments do exist and why the administrative state does exist. Even with the condition here of potentially making it far easier and or even more palatable for a company to deregulate itself, essentially by challenging over and over again regulations. The reason these regulations exist is because governments are filled with the sovereignty to have the power to regulate externalities. Markets sometimes provide too much things like pollution or not enough things like healthcare, public goods, the ability to produce goods that wouldn't be produced, period, in a market. Information asymmetry, where people will have far more information in a market and others far less to be able to know what products are safe or which ones to buy. Monopoly power, allowing the opportunity through contracting out of government services for monopolies to exist, which again are reasons why we created government in the first place. Inequality, stamping out inequality, keeping some equity in the lives of Americans and people around the world. All of these things we tend to forget about as we tend to hear arguments about the market doing a better job than government at doing this or that, or that government should be run like a business or like a market. I say all this to say that we are seeing to Frank's point, we are seeing a continued interest that's occurred for centuries in having markets try to dominate the functions of government when of use to them. And I just needed to jump in and say that when we see these types of efforts, we are seeing an encroachment on the ability of government to do the work that it needs to do when markets do indeed fail.
Thank you, Roger. The next question I want to save for last because it includes a bit more thought and maybe some philosophy behind it too, whereas the others might be more straightforward. How will all of this impact the various code of federal regulations?
Well, as I professed at the beginning, I am not a legal scholar, and so I would leave this to John and Stacy more than myself. But I actually, my humble opinion is that federal regulations will be changed as a function of executive intervention, but I don't believe that the judiciary, it's indirectly or directly can really have much impact on that. However, the way that the executive directs that code of or directs changes towards the code of federal regulations, the judiciary then in response can kind of nullify perhaps those directions that lead to again capricious and arbitrary decisions on behalf of.
Well, I would say it's right now it's going to be in turmoil because you have certain actions that the administration wants to take through this whole executive order process, and then that's challenged by the court, and it's remanded. And it said, well, no, you can't do that. But unfortunately, this administration, even when a court says you can't do it, they do it anyway. So if you change the code, and it takes forever, having been there, it takes forever to make the changes in the code. I think it's going to be a churn, because until, the litigation of what is to be, what is actually going to be happens, you can't really make the change. You're going to be constantly in churn in terms of making those changes.
Thank you, Stacy. John, did you have any comment from a lawyer's perspective? You're muted, John.
My hands and everything. The word all, I wouldn't worry about everything getting thrown out the window. So all CFRs, we're talking an enormous, well, I don't know if a lot of it's online digital now, but if you used to go to a library, you could actually see the whole set of CFRs, and it's tremendous. And I'm not sure, I mean, maybe somebody in the administration has their eyes set on figuring out a way to just eliminate all of them and just go by fiat. But I don't see that happening. It's not practical. I think it's going to be subject matter by subject matter, litigated subject matter by subject matter. And as changes are sought, we're going to be battling it throughout the term. And I think at some point, and you're starting to see this a little bit, I mean, even with the senator from West Virginia pushing back on mine safety rules, at HHS. So you're going to see individual congressmen starting to say, hey, don't do this. This is affecting my constituents. And we really didn't, it's really critical to the public health of our communities. I printed that article from the senator in West Virginia, because that's what's going to happen. And, in a variety of subjects, it's going to be very uneven. It's going to be disparate. But so the word all, I wouldn't leave this session by thinking everything's going away.
Let's just let's also not forget that that CFRs are also the ability to change CFRs, and the ability to even have CFRs are still a delegation from the legislation, right? And so even the code for regulations themselves is indeed a regulation to refine the intent of Congress. And so when they come across, the bad side of Congress, they'll end up, discovering that eventually. Just to remember that the Article 2 is about faithful execution of law, not creating law. So,
future administration, there's going to be lots of work to do for all of us.
I'll move to the next question, because it might be more focused. Immigration lawyers view the Loper decision to their advantage, in that administrative warrants via ICE are not valid post-Loper. What are your thoughts?
Well, I don't think that we need to think only about immigration law, but that it just provides a great example of, the fact that, it may be that the concept and the theory of Loper, is in tune with, conservative preferences about the structure of government, but it doesn't provide carte blanche in terms of policy preferences. That policy is different than structure, and structure dictates a lot of policy, right? And so therefore, what we have is a fundamental change in some respect to processes, but we don't have, it hasn't spoken to specific policies. And if you still cannot justify, your policy that's emanating from the administrative agencies as not being arbitrary and capricious, that's not explicitly dictated by Congress, you're still going to run into the same problems as the policies that you were against and the reason that you wanted this structure.
And the application, the actual carrying out of the procedure, the procedural steps of it, because we can see how that's playing out across the country now.
Thank you,
Yeah.
Stacy.
I think, of course, the response to the administration is quite scary. Trump says, I don't have enough immigration judges to give people due process. I got to move faster.
Right.
So there's conflict headed right to the Supreme Court on that issue of whether even not the basic premise of the APA is going to be followed or not.
No, I'm sorry, John, please.
No, I just wanted to say, that question about right to be heard and notice is fundamental to administrative law is being challenged by this administration.
I think that Stacy brought up a really good point that, the APA and administrative procedures are not just about external pointing regulations. Internal rules by which administrators follow are also dictated according to the Administrative Procedure Act, right?
That's right.
And I just want to take that point for a moment to look introspectively at our field of public administration, and if you want to go more broadly, public affairs generally, public policy, political science, right? That we have lost bearings that we had in the 1980s and 1990s from the likes of, John Rohr, from the likes of Rosemary O'Leary and David Rosenblum, that said, we really need to know, the managerial implications of administrative law, right? And I was lucky enough to study under a couple of those people or their legacies. For instance, Lori Naylor, who studied under Dave Rosenblum, was here with us, and I'm really grateful to have gotten that perspective, because I think it's been lost generally in our fields, and I think that it's something that we need to reincorporate those perspectives to understand that, when we're implementing policy, we are implementing law, and therefore there is a basic kind of, fundamental understanding that we need to have of that law in terms of how we convey it to our students, but also the importance of, our students to understand that when they're actually in those, as in their active, careers as practice.
Dr. Resch, I share this with the students, and people have worked for me or with me on integrated team. By what authority do we operate? During the pandemic, often we wanted to charge ahead to do something. It sounded like the right direction because we were blank sheets of paper managing, with the pandemic, because there was no precedent. But we still had to operate within our authority. And so we had to decipher sometimes, well, we want to do this. Under what authority could we do that? Right now, we're in a situation where, given the political climate, many things are being done, and, public managers are having to do things not even given the time to know that they're operating in their authority. And that's why it's going to be challenged legally. But in the interim, things happen, and communities' needs and people needs, while we're litigating what happens to the people. And that's, where the rubber meets the road for public managers.
Thank you, Stacey. I'd like to take this next question, which I think touches on some things that you have said, but also what John has said. It says a trend toward decentralized governance puts pressure on state and local governments to potentially protect the public How do we analyze the regulatory dynamics set by the federal APA framework and its interactions with individual state APAs?
Well, that's a good research project. I know that.
Well,
We have to follow it, just like I know there are many advocacy groups, have bound together and are following all of the litigation that has come out of these executive orders. But we have to find a way to monitor when there's disparity, when there's conflict, but it is putting more pressure on state and local capacity to do it. I mean, it's just all getting pushed back to state and local without the resources, I might add. But I'll say it behooves us from the academic community, from the advocacy community, and those who are trying to do this work in this unprecedented environment to follow that. I think I read that one. I think it was an excellent proposition there, because right now we don't have the infrastructure to do it, but we should think about how we do it.
my reaction, I actually, the preparation and publication of the Code of Maryland Regulations, COMAR, used to fall under my area of responsibility. I had a person who was head of the Division of State Docs, a wonderful scrivener, I used to call him. He was the scrivener for the state of Maryland. He produced all of that. And so, fine, the feds want to go jump off the cliff. Maryland does not need to jump off the cliff. Things within our jurisdiction, we have the authority to promulgate regulations and do that. Now, have to go back and look. Stacy pointed out if there's conflict and we made reference to something federal, we may need to go back and revise it. But we're not commanded by the constitutional structure of our federal system to just roll over and do everything the feds are doing. We can act independently, and we should assert that. And I'm waiting for whether it's a local school board or the governor of Maine or something to say, see you in court, President, go away. We don't need your money. You can't bully us just by being a financial, holding that over our head. And, I mean, my humorous kind of front is, I had a colleague who was a political science professor. He said, we should have let the South succeed. I'd let them succeed now. It would solve our problems. All right. So, but I think state and local action is going to be a path forward as the public sees, well, what works, who's taking care of their citizens, what's working, what's not. And I think in the area of public health is going to be a lead on it.
I'm hopeful.
Health and human service, health and human services.
Right.
I think those two areas we're going to have to. Well, you can tell that's where I'm from.
You're there. You're already.
There's one other.
I want to.
Mr. Willis, I want to just add one other little piece to that, just from the liability standpoint. The False Claims Act, how this administration is trying to use the False Claims Act to really come after states and jurisdictions in terms of signing with the new formulaic grants, everything that you signed this, and now we see that you're not following the federal mandates based on these new things that are being litigated even. That's something that is concerning, that has come up through the professional associations. Like, okay, how is this going to impact how we deliver services? Because we can't blindly just sign off on these new, when you get your allocations, your formulaic allocations, if they haven't cut them all, that False Claims Act provision is now embedded when you sign off.
Well, we can have this discussion here in the hallway here, or in the conference room here on our floor, but it's a question. Don't make an assumption that their assumption is correct, because they have to have authority for interpreting things or doing things. And my reaction to what you're saying, I understand what you're saying. I understand their threat, but do they really have the authority? And that's going to be litigated, you know?
I just want to go back to to John's reference to a Scrivener, and maybe make a small joke at the end to say that, you know, there's a great short story by Herman Melville called Bartleby the Scrivener.
Right.
And maybe the states take the same position as Bartleby, in the sense that I would prefer not to, and wait for the federal government to challenge that stance, and maybe see them as frustrated as the narrator, who just couldn't get his head around the fact that this person just couldn't prefer not to. And yet, and what do I do with that? What do I do with that response, right? And in many respects, the federal government might find themselves in that position in terms of their relationship to the state and the various dictates that seem to be emanating from the executive currently.
Yeah.
I would like to I'm sorry, John, please.
No, I was
continue.
just trying to make a bad joke about Stacy worried about signing.
I would never want to interrupt a bad joke.
Ending up in one of those Louisiana custody places, you know, because she signed the wrong document. I'm not sure she's listening now.
There are two questions. Again, I'd like to collapse them because I think they have domains that are somewhat comparable. Then after that, there's one last question before we wrap up. The first of this pair is, given the state's lack of legal ability to declare bankruptcy, do we see state reliance on federal monies increasing or decreasing in this decentralized governance trend, particularly in public services that take state-federal collaboration? And then the other question, which is related to that, but your advice for those who are or will be public administrators. What advice do you have for practitioners working in public administration at the state level? How can we be proactive as we navigate this new environment? How might this look different for those of us working in blue states that the federal administration is more focused on?
The only thing that I'll speak on really quickly, because I think the other two panelists are better positioned for this, is that you know, federal money is important. It truly is to states and localities, right? But at the end of the day, it is also marginal in respect to their overall budgets. Highway money, federal highway money is one thing, but in terms of infrastructure, it tends to be maybe on the 5% margin of, you know, what's paying to pave your roads. On the education, in terms of education grants, it tends to be marginal in respect to the overall budget and where the overall revenues are coming from. And typically that's from the state and from property taxes at the local level, et cetera, et cetera, et cetera, right? And so states have at least, you know, some, autonomy to operate. And depending on, you know, the political proclivities of their of their populace, and those proclivities are going to shift as well in response to entitlements that are no longer entitled, that constituents are finding are no longer entitled, and the states are going to be quick to point to, well, we don't have that because of this person, not because of us, right? Or because of this entity as opposed to us, ourselves, right? And so, I think that states are going to be politically advantaged in many respects. You're already seeing, from the governor of Maine and the governor of Massachusetts responding forcefully to Trump edicts that they cave to the preferences of the presidency, and with that, that's more from the high level. I would say from a practical level that you two can speak much better and more articulately than I did.
Well, I would say that working very closely with your general counsel, because it's true, because there's a threat to sue. Right before I left the No, I had already left, but after the election, when the letters came to the various jurisdictions about being a safe haven jurisdiction, and that these law firms began to send letters, just because they send a letter to allege that you're doing something wrong as an organization, or they're targeting your jurisdiction. Work closely with the general counsel on anything and everything that could be challenged or is going to let, again, the winners are the attorneys, because you're going to have to litigate. The jurisdictions are going to have to litigate and push back.
I think,
Well,
Bill,
yeah.
you outlined the major entanglement, and I share this with my students every semester about the percentage of federal dollars that states get. And what's really funny is that many of the red states are the ones that have the highest percentage of federal money going their way. Other states in the Northeast and on the West Coast, we are a little more self-sufficient, but transportation is a heavy one, because the federal highways and the bridges and the Amtraks and all of that, that's a heavy federal involvement. And then Medicaid. And that's why Medicaid
Yeah.
is on the table, because Trump during the campaign said, well, states ought to be doing more. States, and you're seeing Mike Johnson, the speaker, and everybody talk about that. And that's going to be a crunch for states. But for like library funding, state of Maryland can absorb that. State of Maryland can absorb, even though the Humanities Council is going to lose $150,000, we have a $67 billion budget. We can absorb $150,000 and protect our arts and cultural institutions or our state parks. We have ability to do that. So it depends on function. And but in the areas of, Bill mentioned, transportation, education, we could do that. I'm waiting. In fact, I think they're close in Minnesota and a few other local school boards to say, I don't want your federal dollars in education. Leave us alone. We're deciding our curriculum. We're deciding, what programs we have. And you're going to see that. People forget that during the No Child Left Behind, there were 7 or 8 states that didn't take the federal money. They didn't want to, go along with Bush's federalization of education and curriculum changes. They said, just don't give us the money, go away. And I think you're going to see that in education, because local school boards are independently elected. They're not, president's not the boss of them. He can't fire them. They're locally elected. They have their own authority to raise revenue through property tax and other means, and their federal dollar share is so small they say go away. So I'm looking forward to that action. I'm hoping that like some strong, like maybe Vermont will do that. We can go.
Even in terms of student loans, don't forget that states have banking institutions as well.
Right.
And if the administration decides to, heavy-handedly regulate, our higher education institutions, at least those land grant institutions, that are within states, that the states could, in theory, start their own student loan programs.
I like that idea. I'm going to go talk to some of our legislators about that.
So a reminder that's in this vein, with the passage of Medicare and Medicaid, there was one state that said, no, thank you, I don't want the money. It was Arizona. And it wasn't until I think 1983 that they finally said, no mas, we'll take the money. So,
Well, you recall that there
we
were a
will
number
have the
of
26
states-
election.
right.
a
That there were a
budget.
number of states doing Medicaid expansion that did not take the expansion. So there were predominantly red states that did not take the Medicaid expansion provisions. But it's a big need. But I think everyone is saying that states have to be proactive in terms of what they can do for themselves in this environment. It's pretty challenging from a financial standpoint. especially with the, the just Medicaid alone, the state shares 50% of that.
And just to, just to say, be careful what you wish for, right? You've pushed and pushed towards, disabling and deconstructing, the capacity of the federal government to operate. You've stressed states' rights. Well, there are going to be states that don't align with your policy preferences, and they are going to grow in their capacity as a function of the deconstruction that you've made to the federal government. We already see it. There's a great organization that has started. It's called Work for America. Some colleagues of mine that started that just last fall, and they have a great website called Civic Match. And for these feds, these experts that are coming out of the federal government, state governments, large municipalities, county governments are advertising jobs, specifically recruiting that expertise to the state level. And if you want to remember, if you want to go back to our, second republic, as opposed to, if you want to go back to being, the difference between an industrialized and an agrarian, society. Well, we're not going to go all the way back to that, but I guarantee you that in those states that value diversity, that value inclusion, that value equity, that you're going to find a much stronger labor market. You're going to find a much stronger regulatory apparatus to ensure equity and due process within those states. And with that, you're going to find severe disadvantages within those states that have been crying for states' rights all this time and a deconstruction of the federal government.
Which I think brings us full circle to the Powell Doctrine. You broke it, you own it.
One thing I wanted to add, because I'm getting some
John.
ideas here from the colleagues. I really think states need to look at the functions that the federal government is shedding and take them over. For example, one that I've been pushing here, and I'll share it with our audience, why not create a Maryland weather operation? Why don't we just, all those employees at the National Ocean, Maryland, let's create it, let's do it, and then we can charge money to corporations and other government agencies that want accurate weather reports. We don't have to do a Sharpie on a map. We can actually publish it. And one thing that NOAA shedded the other day was, and I forward this on to some people in the state, is they're no longer offering weather forecast in Spanish. All right. So why can't Maryland offer weather forecast in Spanish? And we can monetize what the federal government is shedding. I'm circulating ideas like that. So,
well, I think John,
more ideas like that. I think states are going to try to respond, looking for ways to increase their own functions and revenue.
John, you're absolutely on point. And there are even more types of initiatives that are being, proposed and pursued, actively pursued from civil society and states, civil society organizations and states to uptake the capacity losses of the federal government.
Yeah.
And I think, we could feasibly see a future in which, major types of data initiatives in particular, we see the deconstruction of all these, public data sets, that they're going to be taken up by civil society, coalitions really, to protect the integrity and continuation of important data, resources for our society and our economy.
Yeah, data, that's one also pushing too. Those data sets, that's the consortiums of universities can do that too.
I'm appreciative of all that's been said, but you're also reminding me of the inefficiency of federalism. There's some good inefficiency to federalism.
But as they told the Chinese one time, it was deliberately inefficient.
Exactly. Deliberately inefficient, but oh man, the inefficiency of having 50 different states provide functions that could be provided really well by the federal government. That's the shame that we're finding ourselves in. And you said it so well, Bill, with your example. Some states will devolve into deeper poverty. And, the whole purpose of a federal government to provide human services programs is to even that out across states that can't afford it. As we all know, Stacy knows better than anybody in this room. It's where we are, and for now. Like you said, John, the beauty of federalism is it's harder for people who want to destroy things to get that done too, which is there's some faith in that as well. But anyway, gosh, what a great conversation you all have had. This is really, really fabulous.
If I could leave a somewhat open-ended question, and Roger, if you want to wrap it up as dean and take it out, or what you would see some discussion like this, how we might continue this next year, what would be the logical next thing to do? So the question is, from one of our guests, how do we adjust to both the social as well as the practical opportunities that we face, the backlash as well as the flood tide of resolution needs? So that's a practical, but also a more philosophical question. I think you've touched on aspects of it in a number of the answers today. And if there's anything else that you would like to add before we wrap up.
Well, when we see our nation's history, it's kind of funny. As all of this has been going on, I earlier went to the basics of economics about market failure, and then I could have talked about government failure. But it's really interesting that in the times that we're in right now, with really dramatic changes being placed before us by a new administration, takes me back to the framers. I've even found myself periodically on social media quoting the framers day after day to look at John with the Federalist Papers holding up. It's funny to be reminded of the basics sometimes, but the basics tell us a lot. They tell us that indeed, when there's a push, there's often a pushback. There's an opportunity for a pushback, and even throughout our world history, in places where despotism came into being, there was pushback. There was a lot of harm, a lot of horrible things that happened from despots, and then wow, democracies came back. So you've got to think and realize in these times, whether you're on the right or the left, and you're in the middle of a mess, your framers set up a system that was messy by definition, and messy in a way that protects us from making it messier. And so I think that's one little bit of faith I have. I think as the conversations continue, and as we see, the powers that we have of checks via elections and checks via courts and checks via Congress and the presidency and others, we're gonna find ourselves in a new place sooner than later. Now, where that place will be is going to be interesting.
Well, thank you, Roger. Stacy, I see you have your hand up, and I think you might be the last for our discussion today. What I do want to say is that these are perilous times internally, but also externally. Yesterday, I was in Washington, or Monday, I was in Washington. I gave a talk to 17 different nations, and it was on the challenges of global public health. And those challenges are substantial. And at this time, I remember thinking this is quite a professional challenge, because given the initial actions that we've had in the United States, what do I say to this audience that will be both credible, have integrity, and be forward-looking? We can talk details after this, but what we're discussing within our government and the intergovernmental relations here, there are aspects of it that, at least in health and human services, which is what I know, that are internationally resonant too. Stacy?
Well, recently I heard Stacey Abrams. She was a presenter at our conference in San Francisco. That was there last week, and she said we have to have faith that we can own our own possibilities, because the pendulum will swing back. But in these times, how can we build back better? Now, I know that was a part of President Biden's moniker, but we have to look at, and I think the discussion today about what can we at the state and local level do for ourselves, that we have not thought. We have to think differently. But Stacey Abrams left that meeting saying, I charge all of you to own the possibilities.
I think that's an excellent note to wrap up on. I want to
I
thank.
got a comment I can't resist.
Please.
You know that our Ne'er-do-well Defense Secretary had Stacey Abrams' book removed from the Naval Academy Library. So one thing we could do is give all the Naval Academy graduates a copy of Stacey's book.
As a gift.
Here.
Yes, I want to thank each of you for your time, your openness, your expertise. This has really been spectacular. I've been doing this now for about 23, 24 years, and this is one of the better. As they say in Britain, they don't say we're the best. They'll say, well, perhaps one of the better. And this has been that. And I'm thinking about what would be valuable 6 months from now. And if things occur to you, please email me, reach out. If some things in here resonate and I can contribute usefully, let me know. Just as you left us with a comment from someone whom I think we all admire, I'd like to leave you with a comment from a different sector. And that is Alexei Navalny. And in the documentary, when he's being interviewed, he said, you are not allowed to give up. And I think sometimes that's an important aspect of this, because in some ways, to be living on continental or the 50 states of the United States, there is, for many, comfort to that. It's not the same as if you're surrounded by hostile foreign nations. And we have done difficult things in the past, and we can in the future. But I think to re-inspire that we can create and we can do it, it will be hard, but we can do hard things. So I'd like to keep that as a footnote to what you had shared with us today. Thank you very much.
Thank you very much for Alan and Roger for having all of us, and really appreciated the conversation. And thank you to everyone who stayed, and also those who had to leave early. Much appreciated.
Thanks, Bill.
And Dr. Resch, I'll be in touch.
Okay, can't wait.
Fellow
Nice to see you,
fellow
Stacey. Thank you,
MPA.
John.
Thanks, Bill,
Dr.
Stacey.
Lyles, thank you.
Really appreciate it. Great job, Alan.
Thank you, sir.
Excellent. Thank you.
Thank you, Stacey.
Nice.